Good morning. This is yet another important judgment for young lawyers as well as the aspirants for their promotion in the judiciary system, like elevation to judges, etc. Because the most important subject was how to decide whether the homicide is culpable homicide amounting to murder or culpable homicide not amounting to murder. Exact example of this case would definitely help you to understand. I will just read the index subject which is very precise, and if you go and read near about 22 pages of the judgment, para by para, you will be very expert in understanding how 300, 299, 304 part 1 and 300 part 2 are being discussed and it was brought. Here AIR 2023, Supreme Court 3660, AIR 2023, Supreme Court 3660. The best judgment I have ever seen. This is Anbalagan versus State of Tamil Nadu, Madras case. See, the accused was an agriculturist. A person was about to drive lorry to the field of the accused. So he prevented, despite his prevention, he did not stop. Therefore, a weapon, a device, not weapon, it is a device used to cut the plants. That is, they say, for weeding. And mainly this is gardening tool with a small metal blade attached with a wooden handle. He struck him on his head, he died. Then FIR filed under section 302 IPC, but trial court only punished under section 304 part 1 IPC. High Court also confirmed that. The Supreme Court has clearly held, they say, two different terminologies, intent and knowledge, and a separate punishment for provided for an act committed with the intent to cause bodily injury, which is likely to cause death, and for an act committed with the knowledge that act is likely to cause death without intent to cause such bodily injury as is likely to cause death. Here they say he did not intend to cause such body as it is sufficient in the ordinary course of nature to cause death. The weapon is a common agriculture tool. Of course, if a man is hit with a single blow of weed axe on the head with sufficient force, it is bound to cause as here death. However, accused could only be attributed with knowledge that it was likely to cause death. Then they altered to 10 years 300 part 1 to 5 years of 300 part 2. In one my case, even 6 months I got 300 part 2, 304 part 2. Then they very importantly discuss. They say culpable homicide and murder deals with 299 and 300. Culpable homicide is not murder when the case is brought within the 5 exception of 300 IPC. Then still they say, but even though none of the said 5 exceptions are pleaded or prima facie established on the evidence on record, that prosecution must still be required under the law to bring the case under any of the 4 classes of 300 IPC to sustain the charge of murder. If the prosecution failed to discharge this honor, that was if the 300 to get conviction 300, if they fail to bring these 4 classes, then charge of murder would not made out. Therefore, they have to consider 299. The fine difference between two parts of 304 part IPC, the act and accused falls within the first 2 classes of culpable homicide as described under 211, and it is punishable under part 1. If it is false, the other third class, then it automatically comes under 304 part 2. So this is most important. So for further precise, I will go to paragraph 25 and 63. Most important, this must be 25. What they say? 25. Then 60, 61. Already read 25, 60, 61. So far, 60. They say if the intention knowledge as such is described as class 1 to 4 of section 300 IPC, the act will be murder, even though only a single injury was caused. To illustrate, A is bound hand and a foot. B comes and placing his revolver against the head of A, shoots A in his head, killing him instantaneously. Here there will be no difficulty in holding that the intention of B shooting was to kill him, though only single injury was caused. Then they say, murder falling class 1 of section 3, taking another instance, B sneaks into the bedroom of his enemy. A, while later is asleep on his bed, taking aim at the left chest of A, B forcibly flings a sword into left chest of A and runs away. A dies shortly thereafter. The injury A was found to be sufficient in ordinary course of nature to cause death. There may not be difficulty in holding that B intensely inflicted the particular injury found to be caused, and that said injury was objectively sufficient in the ordinary course of nature to cause death. This would bring Act B within class 3 of section 300 and render him guilty of offence of murder, although only single injury was caused. So therefore, everywhere they have discussed about so many examples. Therefore, kindly go through the entirety of judgment, keep the judgment on file and record, so that you can understand clearly how to bring punishment from 300 to 302 to 304 part 1 or 304 part 1 to part 2, and thereafter you can also try to bring under 323, 325, 326, what not. So this is so much important. Then they say the distinction between culpable homicide and murder has always carefully borne in mind while dealing with the charge as 300. Under category of unlawful homicides, both the cases culpable homicide amounting murder and those not amounting to murder would fall. Therefore, they say so many things. And so this paragraph 60 and 61 is most important. They have altered this judgment. So this is most important because I do not want to bore by reading the judgment. Instead, so these things you should understand. For 300 IPC, there should be some 4 classes. If the prosecution failed to bring those the facts proved within that 4 classes, then you can go to 304 part 1 and part 2. So for part 1, there's the prosecution must prove the intention to murder, and part 2, knowledge of murder. It's a very balancing scale of presumption and depends upon the act committed and the behavior of the accused and the circumstances of the sudden fight and provocation. This is a provocation is also that if you attempt to run over the pathway of the field by riding a lorry, automatically you are provoking, not only provoking, your intention was to commit criminal trespass, so many things are there, he is having a right, all these things are discussed. So this is the way you have to understand how to defend criminal law, criminal, criminally prosecuted accused. Best wishes. Happy Lal Bahadur Ji, Jai Jawan, Jai Kisan, who started a career of aggressive sovereignty of our nation. Another one was Mahatma Gandhi's birthday. Third one was at that time I was working as a import and export clerk under a private firm, Govias and Sons, which was still existing at Armenian Street. At about midnight duty, after attending a court trust work, when I returned, I saw people writing on the street that Kamaraj died. So a brave, honest, always thinks about the poor people. A practical chief minister. Best wishes.